Welcome, everybody, to our fourth series of podcasts that coincide with the launch of our fourth issue of Mákook Sélim. My name is Chastity Davis-Alphonse. I'm a proud member of the Cla'emin Nation and married into the Silcotin Nation, and super thrilled today to have Merle Alexander here, who is a sort of a prolific thinker, an amazing lawyer, and we've been so grateful to have Merle's support for our magazine since day one, and also just really thrilled to have him here today to speak to a little bit about the theme of indigeneity, which you can find his article in this upcoming issue that will be coming out in December. So welcome, Merle. Good to see you, and really thrilled to have some time with you to dive into this really complex but important conversation.
Well, thanks so much for having me, Chastity. It's always been, I've always such a great supporter, a big supporter of the work that you're doing, and I really consider it an honor to be involved in the work of Mákook Sélim. And I also really wanted to not be fearful of like taking on a hard topic, especially right now. I think indigeneity is it's weighing so heavily on so many people's minds. I think I think Indigenous advocates like don't shy away from the hard topics. So I was happy to contribute something and hopefully generate a bit more like a topic, a conversation, lead the conversation a bit where I think and hope it will go.
Yes, thank you so much, and I'm really glad that you brought that up, because it is one of those topics that some people shy away from talking about, and I think that that's why there is a lot of ambiguity and vagueness when this topic comes up in the mainstream, but also like for our communities as a whole. And I agree. I think as advocates, we need to be diving in and being willing to have these conversations and to really bring forward some hard truths that have affected the perception or the beliefs of what indigeneity actually is for our communities. So really appreciate you leaning in and not only writing about this, but being open to actually expanding on your article and your thoughts, and for being here today. So my first question it involves talking about the Indian Act, which is, I think, where a lot of the waters get muddied around our indigeneity and so many other things. But for the topic of conversation today about Indigenous identity. So I think that might be a good place to start, is just for our listeners, is how does the Indian Act continue to impact Indigenous identity today?
Well, I mean, the Indian Act, in some ways, has great detrimental effect, and it also affects none of us. So, I mean, I think it doesn't affect the people who are Métis descent. It doesn't affect people who are Inuit descent. I think like the Inuit have I think all the Inuit communities have modern day treaties, and in those treaties have full right to determine who are the citizens of like the Inuit like communities and the nation as a whole. So, I mean, I think for them, the relevance of the Indian Act never did apply to them and doesn't apply to this day. And I think the Métis are still are still, I think that they don't have a regulated or statutory framework, which, is probably as much a blessing as it is like like a hardship, I guess, depending on who you're talking to. But I think they're much more like, they're sort of still working through what their sort of self-governing approach is like on that. For First Nations or Indians under the Indian Act, like I think it still has a very profound effect. And it's not something that's dated in history. I think people often sort of think, like when really significant racist like elements that are applying, they think, well, that's still not going on today. I mean, the fact of the matter is, like the Indian Act is still determining to this day who is like a member and not a member to most First Nations. Like very few First Nations in the country have modern day treaties that determine the statutory framework for who is a citizen or not. So it does still have a really profound effect of whether or not you're on a membership list for a specific band. I guess you could also say in the same context for First Nations, it could potentially be irrelevant for those who are taking over their membership and leaning less into the Indian Act for determining who is a citizen of their nation and more towards their own Indigenous legal orders or their own First Nations legal orders, I guess more like clearer. I think if you take some of that's formalized in that I think communities have their own membership codes, and those are still very colonial driven, like for the most part, at least the membership codes that I've reviewed, like they're still drawing so much, they're still based on an Indian Act framework of trying to determine how many generations, like how far can you trace back your ancestry, and then also operate to exclude certain members. So I mean for clarity, there's those that just First Nations that just solely rely on the Indian Act to determine who's a member or not. There's those that have membership codes, and then there's some that have modern day treaties which allow them to determine their citizenship. But it's not universal. I still think the majority of First Nations are probably like relying on the Indian Act much more than we'd like to admit. And the fact of the matter is that every single time like a court has the ability to determine whether or not the Indian Act is racist and sexist and discriminates against like the whole other variety of sort of like spectrum of sexual orientation, it almost all of the courts and human rights tribunals always conclude that it is still racist, sexist, and colonial in nature. So it's still the most powerful instrument is constantly being determined to be contrary to human rights law, contrary to the charter, and of course contrary to our own legal orders. And that is still the dominant determinant. In fact, obviously we've all been hearing a lot how strangely lots of First Nations really want to lean into the Indian Act or lean into status cards right now, which is such a scary and regressive stance for using a colonial tool against ourselves.
Yeah, thank you for laying that out so clearly for the listeners and to start setting the context to be able to move forward in this conversation. And I agree. I think that I agree with everything you said, and I think that the last statement was really powerful, just about using it against ourselves and so how do we start moving back to reclaiming our own customary laws and our own protocols and governance structures and ways of determining membership. I mean, that is individual to each First Nation, and they have a long history of being able to determine who was a member and who wasn't. And you wrote in this issue about customary law. So I'd be interested in hearing from you, what is it? And what is its legal standing relative to other bodies of law in Canada? So for example, is it considered by the Crown to be as valid and important as a law and an act?
Yeah, well, the Supreme Court of Canada, people I think are moving away from the term customary law. And I think now, at least in the Aboriginal law or Indigenous law context, people are starting to use the term Indigenous legal orders. which is ultimately just to say laws that are of like the indigenous nation, not laws that are delegated through some statute. So, I mean, the Canadian courts, like at the Supreme Court of Canada level, have clearly said that there's a degree of sovereignty that continues beyond the Crown's assertion of sovereignty. And I would say that it's that when they made those sort of statements, things that are internal to the First Nation or the Indigenous nation itself are conclusively remain beyond the Crown's assertion of sovereignty. So we still remain. In other words, I think First Nations still have sovereignty over determining who are their citizens. Most of the places where it's been sort of tested, that's just been conclusively affirmed. I think it's why you see the Crown sort of allow for membership codes, or why the Crown like doesn't really have much to say, or says that's your exclusive jurisdiction determining how you determine who are your leadership or what your electoral process is. Those are things that are internal to the nation. And so since like the Supreme Court of Canada in the Marshall case, like came down now some 15 years ago, like I think it's been pretty like you're on very firm ground, I think, to say that First Nations have the right to determine who are their own citizens. But to conclude, that doesn't mean that very many are actually occupying that area. So I think like Indigenous legal orders are very alive and well. And as you were sort of saying, like nations have never stopped determining who's a family member and what that family member's rights are. I mean, you're a perfect example of that, right? You probably like, as a family member, like you have a modern day treaty, which of course determines membership and citizenship. Then simultaneously, you'll, through familial rights, a body of familial law, and the Chilcotin Nation have that ability to determine like what are your rights marrying into that nation. I mean, all those things are going on partly by affirmation through modern day treaties, but also by just uplifting what is already the Chilcotin Nation's like body of law. All of that to say that I think that Indigenous legal orders are alive and well. We completely can determine who are our own citizens.
Yes, I agree. And it is a good example about just talking about my own like personal experience of being Cla'emin with our modern day treaty, and then just the Indigenous or the Silcotin like protocols of who's a member of their community. Whether you're marrying in or, and I remember my husband, Chief Joe Alphonse, talking about just, prior to contact that they would accept members into their, like people into their nation if they lived their values, if they learned to speak the language, if they, were contributing to the community, and they necessarily didn't need to be Silcotin. They could be, from any number of ethnic backgrounds, but they would accept them in as a member of their nation if they followed, those certain protocols. And so it just is like you've been saying, and like, I said at the beginning of the question, is that each nation has their own way of determining that, who's a member, who's a citizen of their community. And you talk a lot about like your own personal experience in your article as well, about that, your own personal experience and marrying your wife and your children, and how that's all sort of taken place. And did you want to say anything more about that here, or expand on any of that here?
Yeah, well, I mean, it's like the article really tries to sort of show like how impoverished the view of relying on the Indian Act is, and just brings to like a very like simple like and pointed fact that with the sort of colonial and sort of like sexual discrimination like aspects of the Indian Act. When I was first born, I was actually born without a nation. Like I was like, I mean, I don't think people from my own community like thought of it that way. But my mother married a non-status person, she lost her membership in her own band. All right, like in Kirisu Hayes. And it was only through amending Bill C-31 that they sort of, because of these challenges, these many legal challenges, did it all of a sudden a generation was she sort of re-added to her own membership. And then that gave me like sort of like a six, like our, section 6.2 status under the Indian Act. But even then, if I would have married non-status, then my two sons would have had no First Nation. So you can see like this patchwork or Band-Aid approach, like really is just literally a Band-Aid on like a gaping wound. All the fixes that have happened to the Indian Act are trying to patch like a sinking colonial boat. Like the boat's still sinking. Like it's just only a matter of like, it's just patchwork. So, I mean, I think when you take the complete contrast of like just applying Heitsuk and Tsimshian law, I give the example of like how there's I'm in sort of a really a beautiful time in my life, like where like my own nation is really like claiming me as one of their own. And I give this example of like the big house that I attended early this year, where it's probably, I mean, in a career like mine, like for it to be one of the most powerful things that ever happened to me in Indigenous law, is saying something. When I was at the big house in Bella Bella, and they called my son and I up to the floor, and they blanketed us and introduced us to all of our family members. The elders of our family members said, "You are Heitsuk. You're home." That's extremely beautiful on so many levels. It's so powerful because that's Heitsuk law. That's Heitsuk sovereignty alive today in the most powerful place that our law can live, which is, well, one, in the hearts of the nation, but also in the big house. So it's when you contrast that with like being born with no nation to being like uplifted by your own people, the contrast is great. And then like at the same time, in Kirisu, my uncle is giving me I will be like the benefactor. I'll inherit his traditional name, and he's announced this also in the big house. So it's sort of like a binding transfer. And so I'll be a hereditary chief of the Blackfish. So not only will I when you compare that contrast again of like being born without one nation and being claimed by two, not just being claimed by two, but being uplifted to like a status level that is in some ways as high as one can achieve. Now it's just a matter of like, what sort of chief will I be? That will determine like how my name is uplifted over time. But the contrast of the two bodies of law running in parallel, one which would eliminate your citizenship, and the other which would lift you to the highest status, like I don't think the contrast of it can be any more stark. It's also like, I think, a real calling for people to say like, okay, like which body of law do we want to rely on? I mean, there's a bigger question about whether or not we even rely on the idea of the term Indigenous. Mm-hmm. Because, I'm Heitsuk and Tsimshian, you're Tlam and Chakotans. Like in a way, like this word that been elevated at the highest levels of, international law, like has, you know, relying on the idea of it being born indigenous or being of just like of ancestry, and not looking to our own nation's capacity through self-determination to determine who's a citizen or who isn't. Like relying on someone out on a foreign law to determine who is a citizen, to me just seems like that will be continue to be a failed path. And it's the path that colonial forefathers would have wanted us to rely upon, which I think is is the real reason that we have to resist that. I think we also just really need to move away from the impoverished view that think that our citizens, there can only be so many citizens of our nation, because that's not the way that nations are built. Like at least in my community, the process of adoption by a chief to bring in others into the nation to strengthen the nation is something which is a very powerful form of creating greater strength within your nation. If you weren't going to uplift that body of adoption law, or you're going to say, well, that's not real, you weren't born of that nation, so we're just going to negate that. That doesn't seem like something that is going to serve First Nations. That doesn't seem like that's going to uplift our body of law, because that's a tradition born. That seems almost, at least to my knowledge, like something that's very universal to most First Nations across the country. But the idea that you would take that away from yourself, you would deprive that power, does not seem the act of a sovereign.
Yeah, agreed, and very powerful. Weaving in your experience of the big house and weaving that into the situation is really powerful and moving. So appreciate you sharing that here with us today. And you had talked about it being recognized in international law. So I know that there's many people interested in with the adoption of UNDRIP in the House of Commons last year, and also with the adoption of UNDRIP in British Columbia. How does that tie into this conversation, if any?
Well, I mean, I think it's going to, the implementation or UNDRIP is an affirmative tool, so it doesn't create any rights. I mean, mostly, I think at its very core, what UNDRIP does is it uplifts the right of self-determination of First Nations. So to that extent, it uplifts our legal orders. So it is really relevant. I mean, it is a very powerful tool, I think, that can be used in this context. And maybe it might even be more important than it would have normally, because I think there's a general acceptance that the implementation of UNDRIP in BC and in Canada requires us all to admit that the status quo is not working, and that there's a need for change, and that change will be driven by Indigenous peoples themselves, will be driven by the First Nations and the Indigenous nations of this province. So if, I think that it can be really, there's a lot of empowerment to harness there. So, I mean, I think the applicability of it as an affirmative tool could be really great, because I think that conversation is so present, I think, for so many nations across, it's so relevant right now, that people seizing on saying, challenging the Indian Act, saying, you know what? Well, because under both of the federal and provincial statutes say that all BC and Canadian laws must be made consistent with UNDRIP. And there's no way that you can argue that the Indian Act is consistent with UNDRIP. That is not going to be a winning legal argument for any government in any court in Canada. So I mean, if it only triggers that conversation of really having a really like empowered conversation about citizenship, I think that there's a tremendous like it has tremendous uses here. Um, so I think it will be really relevant. Just hope that people hope it'll be used in a positive way, because similarly, you could through rights of self-determination use it in positive and negative ways. You know, which it'll be interesting to see. I think where this dialogue goes. Um, I think we also do have to be generally careful about thinking of it as all First Nations as being having a homogeneous like perspective on it, because I think depending on where you are, sort of on that movement away from a colonial path, I think you could see a range of interactions on how UNDRIP works or doesn't work for them.
Yeah, agreed. And just to start wrapping us up, the topic of indigeneity or Indigenous identity, First Nations identity, Métis identity, Inuit identity has, been largely in the mainstream, hitting the mainstream over the last, number of years, and so I think that if the general Canadian or people who don't know a lot about our history and the Indian Act and laws, they start, reading these articles, it can be confusing to them about our identity and our indigeneity. So do you have any sort of advice to people who are just like reading these articles, like to point them into the direction of how they can become more informed of, or anything like that? Any words of advice or words of wisdom beyond what you've shared here today?
Well, that's a big question. It's I mostly find it just very curious that the mainstream is so interested in having a conversation about our citizenship. Like, I'm curious, like, what's driving that at this time? Because at the end of the day, it's like what I was saying before, like the only legal authority that should determine who is a citizen is like the First Nation themselves, or the Métis community themselves, or the Inuit community themselves of their respective citizen. They're the ones that determine it. The fact that like there is like a real interest in sort of invalidating Indigenous identity, and that is newsworthy, and that certain media outlets like seem to be like particularly interested in that it sells right now. I find that very curious. I think that I hope that like that all this conversation about Indigenous identity does like arrive at its proper place, which is nations saying that's our right. We'll determine who is a member. End of story. And that we don't get caught up ourselves in looking at blood quantums, or determining like how many generations back determine whether or not you're a member of a community, that you actually rely on what you were saying before about whether or not people in a way are torn to our culture, to our laws, to our values. And you stop sort of trying to use false indicators, like how you were born to determine what your current citizenship is. I mean, that may be a material factor. Maybe that's like a black and white way of like determining whether or not someone's a citizen or not. But then that would, to only focus on that sole criteria will breed away our nationhood. like I think those ideas of blend quantum and how many generations back can you trace your nationhood, like those are not tools that are designed by us. And when we start using them, like the end conclusion will be like less citizens. Then we'll just be like, they'll achieve what was always the purpose of all these colonial statutes, which is to sort of just enfranchise like Indigenous citizens into the mainstream. Then we'll achieve like we'll achieve what the white paper always wanted to do. I mean, so I mean, hopefully people just see that that's the path that we're on. That's where the reliance on status cards and the reliance on like where that's going to take us. And that's there's a lot of humility in accepting that that's the wrong path. And maybe we don't know yet. Maybe we feel like we don't have a good enough sense of what our own sovereignty is. But I think that there's also a real intentional, there's a real intentional drive to sort of try and measure our sovereignty against the Crown's. And when we don't see this modern regulatory framework, we think that our laws are worth less. And I think we have to trace back the fact that customary law, like that all governments and all peoples relied on customary law, including the colonial governments that have assumed sovereignty here. So I don't know, there's a lot there, but hopefully some of it's helpful.
Definitely. I think that all of it is, it reminds me of when I was really young and like in my early 20s, and I first heard Judith Sayers from the New Channel Nation speak. And she had called, it was the first time I heard anybody say it, but the Canadian and the provincial governments, junior governments. And that, and just she kind of went on about just how, they're junior and they're young and they're still trying to sort themselves out. And they've made a mess out of our like thousands of years old like Indigenous governance and laws and protocols and ways of being and knowing. So when you're speaking, I keep hearing her say that, close to 2 decades ago now. And just, I agree solely still with what she was saying and what you're saying here as well, is that's our path forward. And just want to ask you if there's anything else you'd like to add before we wrap up. I know there's so many more areas we could dive into here, and you're just a wealth of knowledge, and it's a pleasure to just have the opportunity to listen to you unpack this complex conversation. So anything else that you'd like to add that I haven't asked you?
I can't think of anything particularly. I'm really thankful for the opportunity to have this, to have this conversation and not have and have it as this part of a dialogue. I think it is important for people to understand that disagreeing with each other is all part of furthering this dialogue. And that we can't like having polarized views on this topic is not going to serve us well. We need to lean into our disagreement also to find out where we actually agree. I think that'd be the most important part, is that we don't get caught in the polarization. That we're mindful, and that we're do it in an informed way. I think that would be the wisdom, that's all part of the wisdom that's inherent to us, that we're the benefactors of. And I think that to me is the way forward.
Mm-hmm. I agree. I agree. Thank you so much, Merle, for being here with us today, for sharing the knowledge that you hold as a knowledge keeper for your nations. You say you belong to two. I'm proud to say that I'm walking alongside of you on this advocacy journey and claim you as one of my relatives as well. So just really feel privileged to have the opportunity to chat with you today. And thank you to all our listeners who have taken the time to tune in to our fourth podcast series of Mákook P. Sélim, and make sure that you download our newest publication that's out this December. And also look to supporting our magazine going forward if you work for a company that would like to support the 100% Indigenous content and contributors to this endeavor. So thank you so much. Again, my name is Chastity Davis-Alphonse, and I am the editor of Mákook P. Sélim, and just feeling grateful for the conversation that we had with Merle Alexander today. Have a good day. Take care. All my relations.